United States v. Hubbell, Supreme Court, 2000. Justice Stevens delivered the opinion of the court. The two questions presented concern the scope of a witness protection against compelled self-incrimination. 1. Whether the Fifth Amendment privilege protects a witness from being compelled to disclose the existence of incriminating documents that the government is unable to describe with reasonable particularity. And 2. If the witness produces such documents pursuant to a grant of immunity, whether 18 U.S.C. 6002 prevents the government from using them to prepare criminal charges against him. 1. This proceeding arises out of the second prosecution of respondent, Webster Hubbell, commenced by the independent counsel appointed in August 1994 to investigate possible violations of federal law relating to the Whitewater Development Corporation. The first prosecution was terminated pursuant to a plea bargain. In December 1994, respondent pleaded guilty to charges of mail fraud and tax evasion arising out of his billing practices as a member of an Arkansas law firm from 1989 to 1992, and was sentenced to 21 months in prison. In the plea agreement, respondent promised to provide the independent counsel with full, complete, accurate, and truthful information about matters relating to the Whitewater investigation. The second prosecution resulted from the independent counsel's attempt to determine whether respondent had violated that promise. In October 1996, while respondent was incarcerated, the independent counsel served him with a subpoena duces tecum, calling for the production of 11 categories of documents before a grand jury sitting in Little Rock, Arkansas. On November 19th, he appeared before the grand jury and invoked his Fifth Amendment privilege against self-incrimination. In response to questioning by the prosecutor, respondent initially refused to state whether there are documents within my possession, custody, or control responsive to the subpoena. Thereafter, the prosecutor produced an order which had previously been obtained from the district court pursuant to 18 U.S.C. 6003A, directing him to respond to the subpoena and granting him immunity to the extent allowed by law. Respondent then produced 13,120 pages of documents and records and responded to a series of questions that established that those were all of the documents in his custody or control that were responsive to the commands in the subpoena, with the exception of a few documents he claimed were shielded by the attorney-client and attorney work product privileges. The contents of the documents produced by respondent provided the independent counsel with information that led to this second prosecution. On April 30th, 1998, a grand jury in the District of Columbia returned a 10-count indictment charging respondent with various tax-related crimes and mail and wire fraud. The district court dismissed the indictment, relying in part on the ground that the independent counsel's use of the subpoenaed documents violated Section 6002 because all of the evidence he would offer against respondent at trial derived either directly or indirectly from the testimonial aspects of respondent's immunized act of producing those documents. The Court of Appeals vacated the judgment and remanded for further proceedings. 2. It is a settled proposition that a person may be required to produce specific documents even though they contain incriminating assertions of fact or belief because the creation of those documents was not compelled within the meaning of the privilege. On the other hand, we've also made it clear that the act of producing documents in response to a subpoena may have a compelled testimonial aspect. We have held that the act of production itself may implicitly communicate statements of fact. By producing documents in compliance with a subpoena, the witness would admit that the papers existed, were in his possession or control, and were authentic. Moreover, as was true in this case, when the custodian or documents responds to a subpoena, he may be compelled to take the witness stand and answer questions designated to determine whether he has produced everything demanded by the subpoena. The answers to those questions, as well as the act of production itself, may certainly communicate information about the existence, custody, and authenticity of the documents. Whether the constitutional privilege protects the answers to such questions or protects the act of production itself is a question that is distinct from the question whether the unprotected contents of the documents themselves are incriminating. 3. Acting pursuant to 18 U.S.C. 6002, the district court entered an order compelling respondent to produce any and all documents described in the grand jury subpoena and granting him immunity to the extent allowed by law. The compelled testimony that is relevant in this case is not to be found in the contents of these documents produced in response to the subpoena. It is, rather, the testimony inherent in the act of producing those documents. The disagreement between the parties focuses entirely on the significance of that testimonial aspect. The government correctly emphasizes that the testimonial aspect of a response to a subpoena, duces tecum, does nothing more than establish the existence, authenticity, and custody of items that are produced. We assume that the government is also entirely correct in its submission that it would not have to advert to respondent's act of production in order to prove the existence, authenticity, or custody of any documents that it might offer in evidence at a criminal trial. Indeed, the government disclaims any need to introduce any of the documents produced by respondent into evidence in order to prove the charges against him. It follows, according to the government, that it has no intention of making improper use of respondent's compelled testimony. The question, however, is not whether the response to the subpoena may be introduced into evidence at his criminal trial. That would surely be a prohibited use of the immunized act of production, but the fact that the government intends no such use of the act of production leaves open the separate question whether it has already made derivative use of the testimonial aspect of that act in obtaining the indictment against respondent and in preparing its case for trial. It clearly has. It is apparent from the text of the subpoena itself that the prosecutor needed respondent's assistance both to identify potential sources of information and to produce those sources. Given the breadth of the description of the 11 categories of documents called for by the subpoena, the collection and production of the materials demanded was tantamount to answering a series of interrogatories, asking a witness to disclose the existence and location of particular documents fitting certain broad descriptions. The assembly of literally hundreds of pages of material in response to a request for any and all documents reflecting, referring, or relating to any direct or indirect sources of money or other things of value received by or provided to an individual or members of his family during a 3-year period is the functional equivalent of the preparation of an answer to either a detailed written interrogatory or a series of oral questions at a discovery deposition. Entirely apart from the contents of the 13,120 pages of materials that respondent produced in this case, it is undeniable that providing a catalog of existing documents fitting within any of the 11 broadly worded subpoena categories could provide a prosecutor with a lead to incriminating evidence or a link in the chain of evidence needed to prosecute. Indeed, the record makes it clear that this is what happened in this case. The documents were produced before a grand jury sitting in the Eastern District of Arkansas in aid of the independent counsel's attempt to determine whether a respondent had violated a commitment in his first plea agreement. The use of those sources of information eventually led to the return of an indictment by a grand jury sitting in the District of Columbia for offenses that apparently are unrelated to that plea agreement. What the district court characterized as a fishing expedition did produce a fish, but not the one that the independent counsel expected to hook. It is abundantly clear that the testimonial aspect of respondent's act of producing subpoenaed documents was the first step in a chain of evidence that led to this prosecution. The documents did not magically appear in the prosecutor's office like manna from heaven. They arrived there only after a respondent asserted his constitutional privilege, received a grant of immunity, and, under the compulsion of the district court's order, took the mental and physical steps necessary to provide the prosecutor with an accurate inventory of the many sources of potentially incriminating evidence sought by the subpoena. It was only through respondent's truthful reply to the subpoena that the government received the incriminating documents of which it made substantial use in the investigation that led to the indictment. For these reasons, we cannot accept the government's submission that respondent's immunity did not preclude its derivative use of the produced documents because its possession of the documents was the fruit only of a simple physical act, the act of producing the documents. It was unquestionably necessary for respondent to make extensive use of the contents of his own mind in identifying the hundreds of documents responsive to the requests in the subpoena. The assembly of those documents was like telling an inquisitor the combination to a wall safe, not like being forced to surrender the key to a strongbox. The government's anemic view of respondents' act of production as a mere physical act that is principally non-testimonial in character and can be entirely divorced from its implicit testimonial aspect so as to constitute a legitimate, wholly independent source, as required by Castigar, for the documents produced, simply fails to account for these realities. In sum, we have no doubt that the constitutional privilege against self-incrimination protects the target of a grand jury investigation from being compelled to answer questions designed to elicit information about the existence of sources of potentially incriminating evidence. That constitutional privilege has the same application to the testimonial aspect of a response to a subpoena seeking discovery of those sources. Given our conclusion that respondents' act of production had a testimonial aspect, at least with respect to the existence and location of the documents sought by the government subpoena, respondent could not be compelled to produce those documents without first receiving a grant of immunity under Section 6003. As we construed Section 6002 in Castigar, such immunity is coextensive with the constitutional privilege. Castigar requires that respondents' motion to dismiss the indictment on immunity grounds be granted unless the government proves that the evidence it used in obtaining the indictment and proposed to use at trial was derived from legitimate sources wholly independent of the testimonial aspect of respondents' immunized conduct in assembling and producing the documents described in the subpoena. The government, however, does not claim that it could make such a showing. Rather, it contends that its prosecution of respondent must be considered proper unless someone, presumably respondent, shows that there is some substantial relation between the compelled testimonial communications implicit in the act of production, as opposed to the act of production standing alone, and some aspect of the information used in the investigation or the evidence presented at trial. We could not accept this submission without repudiating the basis for our conclusion in Castigar that the statutory guarantee of use and derivative use immunity is as broad as the constitutional privilege itself. This we are not prepared to do. Accordingly, the indictment against respondent must be dismissed.